All right, good morning, everyone. I'm Judge Margaret Schreiber. We're here for initial appearances. We're starting with Osceola. May I have appearances for the record, beginning with the State Attorney's Office.
Good morning, Your Honor. Eric Jenkins for the state.
Kelly Hicks on behalf of the state if needed.
Thank you. Who's here for the Public Defender?
Alicia Smith on behalf of the Public Defender's Office, Judge. Good morning.
Good morning. Did you say Alicia Smith?
Yes, Judge.
Okay, thank you. Folks, you all should have seen a video that expanded on everything I'm about to tell you. The purpose of initial appearances is to advise you of the charges, appoint counsel if you are qualified, and to set a reasonable bond if you are qualified. Let me ask if we have the Spanish interpreter online.
Yes, Judge. Good morning. The interpreter is available and connected.
Okay, perfect. I will call the folks needing a Spanish interpreter first, and thereafter we will call everybody else. So who do we have on cue for the Spanish interpreter today?
Harlan Lemus Mejia.
All right, give me a
Do
second.
you want me to give you all of them, Judge, or just one at a time?
Why don't you give me all of them? Mejia?
Next would be Jesus. Yes, Judge. Next would be Jesus Nieves Flores. And last would be Joel Sierra Martinez.
Thank you. And for everybody down there, when I call your name, I need you to come up to the podium, please. Mr. Interpreter, have you been sworn today?
Yes, Judge.
Okay, I think you said that. So let's start with, let me get to Mejia.
Lemus Mejia, Judge.
Lemus Mejia.
Mejia, come on, sir, vamos.
We'll waive the reading of the charges, Judge.
Alrighty. Two things. State, if I ask for a bond recommendation, I would ask that you provide me with a bond recommendation or let me know if you want it to be judge's discretion. Two, if there is a probable cause challenge, I would ask that the defense counsel advise me that there is a probable cause challenge. Mr. Interpreter?
Yes, Judge, the interpreter would also ask if there are any case numbers for these cases, if they can be provided to the interpreter, please.
These cases haven't been filed on yet.
Okay.
So, okay. Mr. Mejia, first of all, you have the right to remain silent. Anything you say can and will be used against you.
Señor Mejía, primeramente usted tiene el derecho a guardar silencio. Cualquier cosa que diga puede ser usado en su contra.
I'm appointing the Office of the Public Defender to represent you at this time.
En este momento le estoy nombrando a los defensores públicos para que lo representen.
Counsel, you waive the reading of the charge?
Yes, Judge.
All right.
La abogada renunció a la lectura de los cargos.
May I have a bond recommendation from the state?
Your Honor, the state would just ask that you follow the bond schedule, and if there was anything out of the ordinary, the state would inform you.
La Fiscalía pide que se sigan las pautas sobre la fianza.
Well, the bond schedule is 0 until IAs. So, I've reviewed the charging affidavit. I do find there is probable cause for the charges.
He leído el affidavit acusatorio, determinó que existe motivo fundado para los cargos.
Bond is set at $5,000 with the conditions that there be no contact with the alleged victim.
La fianza es de $5,000 con la condición de que está prohibido el contacto con la supuesta víctima.
No return, except on a one-time basis in the presence of law enforcement to gather his personal possessions.
Prohibido regresar al lugar de los hechos o a esa residencia, con la excepción de que puede regresar una vez acompañado de las autoridades para recoger sus pertenencias.
And do we have dates for him, or he'll get that? You'll get dates most likely next week.
Lo más probable es que la próxima semana se le informará de las fechas para las siguientes vistas.
You may be seated.
Tome asiento.
Jesus Nieves Flores. I'm appointing the Office of the Public Defender to represent you at this time.
Voy a nombrar a la Oficina de los Defensores Públicos para que lo representen.
Anything you say can and will be used against you in a future proceeding.
Cualquier cosa que usted diga puede ser usado en su contra en una vista futura.
You're here pursuant to a warrant issued for violation of your probation and/or community control.
Usted se encuentra aquí por una orden de arresto por la acusación de haber incumplido con su régimen de probatoria o control comunitario.
The warrant was issued by Judge Morgan and set your bond at $1,000.
El juez Morgan fue el que emitió esa orden de arresto y la fianza que se le asignó es de $1,000.
And you may be seated.
Tome asiento.
Is it
Judge, there's
Yolanda
one more that
Martinez? Okay, Yolanda
No,
Martinez.
it was Joel,
Who was it?
for interpreter, is Joel Sierra Martinez. And then I missed one earlier, Ebrin Mendoza.
All right. Well, let me see if I can find Sierra Martinez, might be under S. It is. Joel Sierra Martinez. Mr. Martinez, I'm appointing the Office of the Public Defender to represent you.
Señor Martínez, estoy nombrando a la Oficina de los Defensores Públicos para que lo
You're charged with fleeing or eluding a law enforcement officer with lights and siren activated.
Se le acusa de darse a la fuga y de huir de un oficial del orden público que tenía las luces y las sirenas activadas.
I find probable cause for the charge.
Determinó que sí hay motivo fundado para esa acusación.
Bond is set at $5,000.
La fianza es de $5,000.
Judge, he does qualify for direct pretrial release. Would the court do direct pretrial release in this case?
Él reúne los requisitos para salir bajo el Departamento de Libertad Provisional. ¿Lo haría, juez?
Not based on this charge, counsel.
Basado en este cargo, no.
You may be seated.
Tome asiento.
Mendoza? Freddie Mendoza. Okay.
No, it's Ebrin, sorry, Judge, the next one. Mendoza Morjan.
Ebrin Mendoza Morejo. I'm appointing the Office of the Public Defender to represent you.
Estoy nombrando a la Oficina de los Defensores Públicos para que lo representen.
You're charged with one count of trespass to an unoccupied structure or conveyance.
La acusación es de entrar ilícitamente a una estructura no habitada o desocupada o a un medio de transporte.
I find probable cause for the charge,
Determinó que sí hay motivo fundado para esa acusación
and I'm releasing you under direct PTR conditions.
y le estoy permitiendo salir bajo las condiciones del Departamento de Libertad Provisional.
You may be seated.
Tome asiento.
Mr. Interpreter, would you please announce the following? If anyone else has need of the Spanish interpreter, please raise your hand and let us know.
Si hay alguien más que necesita los servicios de un intérprete en español, levante la mano, por favor.
Any hands, counsel?
No, Judge.
All right, can we release the interpreter at this time? Pardon? Oh, okay, we still have Orange County to go, so I guess you just hold on.
Yes, Judge.
All righty. Zaybun Nisa Ali.
Good morning, ma'am.
Good morning. I'm appointing the office, you're waiving your right to representation by counsel. So,
Oh, sorry, Judge, because it's an out-of-county warrant, we don't do the affidavits here.
gotcha, I understand, it's an Orange County warrant. Okay, I show that you are charged with, a warrant was issued for failure to appear
Yes, ma'am.
in an Orange County proceeding. The underlying charges were fleeing and attempting to elude a law enforcement officer with lights and siren activating, and driving while license suspended with 2 prior convictions. Your bond was set at 0. In that case, you'll be held for transport.
So I go to court in Orange County?
Yeah, they'll transfer you to Orange County.
Okay.
Take a seat, please. Andrew Davis. Mr. Davis, I'm appointing the Office of the Public Defender to represent you. You're charged with 1 count battery, simple touching, or striking. I've reviewed the charging affidavit. I do find there is probable cause for the charge. I'm setting your bond at $1,000 with PTR conditions, including no contact with the victim. In this case. All right?
Thank you, Judge.
Aaron Gerzon. Mr. Gerzon, I'm appointing the Office of the Public Defender to represent you in each of these 3 cases. You're charged in case 1 with battery, causing bodily harm, and resisting arrest without violence. And the battery, I believe, was domestic in nature. It was. I find probable cause for the charges. Your bond is set at $1,000 on count 1, $500 on count 2. You're to have no contact with the alleged victim in this case. Case 2, I'm driving while license suspended, first offense. Again, I'm appointing the Office of the Public Defender to represent you. I find there is probable cause for the charge. Your bond is set at $500. And last but not least, there's a charge for violation of your probation or community control. One of the requirements of your probation and or community control is that you not pick up any new charges while you're out on it. Based upon an on-view violation of your probation, your bond is set at 0 on that count. And I'm appointing the Office of the Public Defender to represent you on that too.
Judge, the defendant is out on bond in Orange County for a battery case, 19MM8617.
Thank you. I'm finding an on-view violation of that case and revoking any conditions of release and setting bond at 0, no bond. You can be seated. Alexander Hernandez Colon. Mr. Colon, you have 2 cases. One is driving while license suspended with knowledge, your first conviction. 2 is battery, simple touching or striking, domestic in nature. I find probable cause for the license suspension count. And probable cause on the battery count. On the traffic charge, I'm releasing you. Under direct PTR conditions. Actually, no, I'm going to release you ROR on the traffic count. On the battery count, bond is set at $500, and you're to have no contact with the alleged victim. I did appoint, did I appoint the PD? I'm appointing the public defender to represent you on both cases, if I didn't do it.
Okay, thank you, Judge.
Alrighty. Cesar Geraldo Rivera. Mr. Rivera, I'm appointing the Office of the Public Defender to represent you. You are here because Judge Arendas issued a warrant for your failure to appear on a written promise, specifically at your pretrial for the underlying case of possession of drug paraphernalia. Your bond is set at 0. Conduct quo. Sir, I'm appointing the Office of the Public Defender to represent you on both cases. I have 2 arrest reports. You are charged with the following: fleeing and attempting to elude a law enforcement officer with lights and siren activated, driving under the influence of alcohol or drugs, reckless driving, first offense, and obstruction without violence. I reviewed both charging affidavits. I do find there is probable cause for the charge. I find the facts underlying the fleeing and eluding a law enforcement officer with lights and siren active to be particularly egregious. I'm setting your bond on that count at $10,000. Your bond is set on each of the other counts at $500. You are to not possess or consume any, you're not to drive under the influence of any alcohol or drugs. And we're going to leave it at that.
Just to be clear, Judge, that's 500 on the resisting, 500 on the reckless, 500 on the DUI, then 10,000 on the fleeing.
I got all 4 counts. What did I miss? I did them together. So, that is correct.
Okay, thank you, Judge.
Judge, the defendant is out on state probation, 2 interstate case and a Broward County case.
I
Are
have
you
no-
going to be taking any action?
I have no jurisdiction to take any action on an out-of-county,
Yes, Judge.
I don't believe. So I'm not taking any action. Lillian Maldonado.
Good morning.
Good morning. I'm appointing the Office of the Public Defender to represent you. You're charged with 1 count of battery, touching, or striking. I do find there's probable cause for the charge. Bond is set at $1,000 with PTR conditions. You're to have no contact with the alleged victim. If you reside together, you're to maintain separate residences. You're also not to possess or consume any alcohol or illegal drugs or controlled substances without a valid prescription. That's all. Jonathan Mandley.
Good morning, Your Honor.
Good morning. I'm appointing the Office of the Public Defender to represent you. You're charged with violation of probation and/or community control for, looks like another case involving a DeWillis. Judge Arenda, set your bond at $0. Kendall Marshall.
Good morning.
Good morning. I'm appointing the Office of the Public Defender to represent you. You are charged with violation of your probation and/or community control, and bond is set at $0. Yolanda Martinez. Good morning. I'm appointing the Office of the Public Defender to represent you. You're charged with 1 count of battery, simple touching or striking, domestic in nature. I have reviewed the charging affidavit. I do find that there is probable cause for the charge. Bond is set at $1,000 with PTR conditions. You're to have no hostile contact with the alleged victim. That's it. Freddie Mendez.
Good morning, Your Honor.
Good morning. I'm appointing the Office of the Public Defender to represent you. You're charged with 1 count of battery, simple touching, or striking. I find probable cause for the charge. Bond is set at $1,000. You're to have no contact with the alleged victim. If you currently reside together, you're to maintain separate residences.
Yes, the defendant is out on probation for Osceola County, case 1804225, burglary on a occupied structure. He also has an open case for Osceola County, which is on drug court. Are you going to take action on the probation?
I
Judge?
am. I'm going to find a non-view violation of his probation or conditions of release and set his bond at $0.
What's the case number?
18 CF 4225.
And that's on the one he's out on probation for. The other one, are there conditions of release? Are there 2 cases?
It's the same case, Judge.
Okay, good enough, thank you.
Can we be appointed as to the violation of probation?
Yes, you
Judge?
can. You are appointed. Rebecca Rayleigh. I am appointing the Office of the Public Defender to represent you. You're charged with trespass on a posted construction site and possession of burglary tools. I find there is probable cause for the charges. No, the one I just, it was paperwork I gave you. I already called him. Yeah, we did them already. Okay, I'm setting your bond at $500 on count one, $150 on count two. Also finding an on-view violation of your probation or community control in Polk County. Setting your bond at 0 pending their notification. Folks, who was the one that had, had a case in Broward County?
I believe that was Mr. Lee or Lou.
Yeah, Lee Kwan or Lee Kuo. Is he still in the room?
Yes, Judge.
I want to recall him.
You want to recall him now, Judge?
I simply want to recall him. Yes, I do.
He's approaching.
Could you advise the court what he's out for, or what the Broward County case is about? Is he out on probation, parole?
Judge.
What?
Judge, the case for Broward County is he's out of state probation for possession of cocaine.
I'm going to find an on-view violation of his probation. Based upon the new charges. Do you have the case number?
Yes, Judge.
Is it 2017 CF 14781?
It's 2019 CF 14781.
Okay. All right, thank you. Michael Rivera Mercado.
Good morning, Judge. Steve Caresti is appearing for Mr. Michael Rivera Mercado on behalf of law firm of Jake Stewart.
Good morning.
Good morning, Judge.
Mr. Mercado.
Yes, Judge. An affidavit, a declination has already been filed in this case. I have a copy here this morning as well if anybody needs it, but it has been filed, as well as a motion to set bond. I don't believe the state has any objection to bond, but it's not agreeable to a certain amount. The bond motion specifically asked for a motion for ROR because the declination has already been filed and signed and notarized by the alleged victim in this case. If Your Honor is not willing to do that, then we just ask for the lowest bond Your Honor feels comfortable with. The co-defendant's bond was set at $7,500.
Are you waiving the reading of the charge?
Yes, Judge.
What says the state?
Your Honor, even with the declination being filed, the state would ask at this point that the charges this remain. If Your Honor wants to set bond in this case, we would just ask that they would have no contact with the victim, or if they reside together, that it be no hostile contact, and they'd have to maintain separate residences with the no contact order. Being a regular no contact order, Your Honor. I'm sorry.
I didn't hear the end of that, sir.
I'm sorry.
I just wanted to clarify that. Sorry.
Judge, you have to order, the state would be asking that you order no contact. You're also required by law to set a bond because it is a domestic case. The state is and The state had a conversation with the attorney who represents them, and we agreed that a bond would be set, a reasonable bond, since it's a crime of violence.
Okay. I'm not going to release them ROR, counsel, but I will set a bond. I'm going to set a bond of $1,000. I'm going to order that there be no contact, direct or indirect, with the alleged victim, no return except on a one-time basis in the presence of law enforcement to gather his personal possessions in the event they reside together. And possess no weapons or firearms.
Judge, we found the defendant being out on bond, but at this time, I'm not sure if this arrest violate those bonds.
This was a warrant case, Judge. I'm not sure of the dates.
This was, I'm going to take no action on those other bonds.
Yes, Judge.
Anything else on this one, folks?
No, ma'am.
All right, thank you.
Thanks, Judge.
Shatasia Shelton. Okay, you are charged, first of all, I'm appointing the Office of the Public Defender to represent you. You're charged with petty theft from a vehicle in an amount less than $300, battery, simple touching or striking, and burglary of an auto or other conveyance which was unoccupied at the time. I've reviewed the charging affidavit. I do find there is probable cause for each of those charges. I'm setting your bond at $3,500 on the burglary auto count, $250 on the petty theft count, and $250 on the battery count. You are also charged with violation of a domestic injunction in case 2019 MM 2600.
She's out on bond on that case, Judge.
She's out on bond?
That's correct, Judge.
All right, give me a second then.
It was dropped. The injunction was dropped.
Do the new cases involve the same individual?
I'm not aware, Judge. The case she's out on bond is a violation of a domestic injunction. She has a court date on November 26th at 8:15 here in Osceola.
One of the conditions of your release are that you not pick up any new charges. You've done that. I'm revoking the conditions of your release, revoking your bond in the 2019 MM 2600 case, setting your bond at zero, to be addressed by the presiding judge in that case.
If we're not appointed, can we be appointed as to that
Yes.
misdemeanor case, Judge?
You are appointed.
Thank you.
Sarah Stevens.
I'll talk to them.
You are charged, I'm appointing the Office of the Public Defender to represent you. You are charged with violation of your probation and/or community control. Your bond is set at zero. Cynthia Tackett. I'm appointing the Office of the Public Defender to represent you. You're charged with possession of burglary tools and trespass on a posted construction site. I find probable cause for the charges. Your bond is set at $500 on count one and $150 on count two, for a total bond of $650. I You qualify for direct PTR, and I'm setting your release under direct PTR conditions. Actually, disregard the bonds that I just talked about. Those are the standard bonds, and I'm not giving you that. So in lieu of the bond you're having, I'm releasing you under direct PTR because you qualify. Romina Cortez. Ms. Cortez, you are here based upon a warrant for violation of your probation and/or community control issued by Judge Whitehead, who set your bond at 0. And I am appointing the Office of the Public Defender to represent you. Felix Perez Bello.
He's coming from the back, Judge, and we'll waive the reading of the charges.
All right.
Good morning, Your Honor.
Good morning. I'm appointing the Office of the Public Defender to represent you. Counsel, are you waiving the reading of the charges? You already
Yes,
did,
Judge.
yes? Okay.
Yes, Judge.
All right. I do find probable cause for each of the charges. Is there a bond recommendation by the state?
Your Honor, we would just ask that you follow the bond schedule with this case and have no contact with the victim in this case.
One moment, Judge. There's no bond schedule. It's no bond, please. Judge, the state would be asking for $10,000 on each count. Oh, hold on a second, I'm sorry. Victim under the age of 12, the defendant's not entitled to a bond. Judge, the state would be asking for no bond.
What says the defense?
Judge, there's no indication of age aside from the conclusory statement by the police. There's nothing to indicate age. We'd be asking for a bond on the F2, the lesser basically that would entitle him to bond, and we'd ask for no more than $5,000 per count.
I see nothing indicating age, state, so
Judge, the state would ask for a 24-hour reset to establish probable cause based on the age of the victim in this case.
done. We'll reset it for tomorrow. I'll give you 24 hours to file a supplemental affidavit addressing the age of the alleged victim.
Thank you, Your Honor.
Bond will be stayed at 0 until then, Judge?
Bond will be set at 0 until then. Yes, ma'am.
Okay, thank you, Judge.
Can we go back to Freddie Mendez? I need Freddie Mendez. I'm sorry? I'm actually asking, I need PTR on this one, I'm sorry. The 2018 CF 4225, which is the drug case, was an open case. Was he on release on bond? What were the conditions of his release?
He's on probation, Judge. I'm looking for the paperwork, Judge.
Almost done too.
So he's on probation for Osceola County State Probation, Judge. You did an on-view violation on the 18 CF 4225.
All right, that's what we did, thank you. We're just double checking our paperwork.
Thank you, Judge.
Is there anybody in the room that's not been called? All right, thank you, folks. Tomorrow, same time?
Judge,
Yes.
which time, same time, Judge? I know that you were saying you wanted to start early, so when you say same time, 10:30 or 10 o'clock?
Let's start at 10:30 tomorrow. Give everybody time to get the paperwork in, all right? Does that work?
Perfect, thank you, Judge.
Great, thank you.
That's fine.
Bye. Okay, good morning, everyone. We're here for initial appearances. I'm Judge Margaret Schreiber. May I have appearances beginning with the state?
Eric Jenkins for the state.
Kelly Hicks on behalf of the state.
Thank you.
Courtney Daly with the Public Defender's Office.
Thank you. Okay. Wilmer Villaray Nazelaya. And that's the Spanish interpreter case? And we
Yes.
have the interpreter online?
Can you hear me,
Y-
interpreter?
y- Yes, yes, Judge. Is there a case number for this case or no?
I don't believe so. Do we have a case number for this? Stand by. Ah, we do.
CT 8026.
I cannot hear you.
Are we good to go?
2019 CT 8026.
80. It's 2019 CT 8026.
Can he hear me?
Can you hear the judge? Okay.
Yes, Your Honor, the interpreter's here.
Okay. Very good. Sir, I'm appointing the Office of the Public Defender to represent you.
The interpreter's coming across very quiet. I don't think he can hear.
Yeah.
Yes, he can hear me.
Okay.
Okay, and you're interpreting for him? Did you just say
Yes.
what I said?
Yes, Your Honor.
Okay. I'm sorry? Okay, good enough. That's new since the last time I was over here. You have the right to remain silent. Anything you say can and will be used against you. You're charged with one count of driving with no valid driver's license. I've reviewed the charging affidavit. I do find there's probable cause for the charge. Your bond is set at $500.
Thank you.
All right. Do we have any other cases where we need a Spanish interpreter?
I don't have anything that notes that we do.
Okay. Sir, thank you.
Thank you, Judge.
Leonardo Ernesto Minoso, also known as Leonard
Present.
Minoso.
Right here. Yes, ma'am.
All right.
Yeah.
Sir, I'm simply going to advise you that there is an immigration detainer
Yep.
that's been placed against you. So I don't have any charges or separate charges other than this immigration detainer. So you're just going to be held until such time as the Department of Homeland Security has been notified that you are here and can decide what they want to do with you. All right?
That's it?
That's it.
All right.
Benjamin Owens.
Morning, Your Honor.
Good morning.
James Fierstein, I'm here on behalf of Benjamin Owens, case 2019 CF 015216.
Okay. Mr. Owens is charged with aggravated assault with a firearm, domestic violence, a domestic violence charge, and assault, a domestic violence charge. I've reviewed the charging affidavit. I do find there is probable cause for the charge. Do you care to be heard on bond?
Yes, Judge, I don't believe he has any prior criminal history other than a child alcohol charge in New Hampshire. I believe other than that, he has no prior criminal history. Judge is in the process of moving out in this relationship and not planning on having any contact with her. And just ask that bond be set the schedule below.
All right. Does the state care to be heard?
Your Honor, Eric Jenkins for the state. The state would ask that there be no contact with any victims in this case and just follow the schedule for the bond.
All right. Bond is set at $5,000 on count one, $150 on count two. He's to have no contact with the alleged victim. He's got zero history? Is that what you
I
said?
believe he had a
Let me double check.
about providing alcohol to a minor in New Hampshire. House party type charge in New Hampshire. That was.
All right, I'm going to drop that $5,000 bond down to $2,500. He's to have no contact with the alleged victim, direct or indirect. He's to possess no weapons or firearms. He's not to return to the scene of the offense, except on a one-time basis in the presence of law enforcement to gather his possessions in the event he's got possessions there. And I think that'll do it.
Judge, he was in the process of moving out. I know it's usually they do it very quickly, but he believes he can have all of his stuff out within 2 hours. Court could, usually the law enforcement doesn't want to stay that long, but
Well, that's true.
he would try to get everything out so he doesn't have to have anything there.
As long as she's not there, or the victim is not there when he's moving out his possessions, I'm fine with that. So he may return on a one-time basis to complete his moving out, as long as the victim is not there. When he does so, the victim may have a representative there to make sure he's not taking any other stuff other than what belongs to her. Otherwise, it's going to have to be in the presence of law enforcement.
Thank you, Your Honor.
All right? Bethany Brooks. Bethany Brooks. I'm appointing the Office of the Public Defender to represent you. You're charged with one count of battery, domestic in nature. Ma'am, what is your name and your relationship?
My name is Sherry Brooks, and I'm Bethany's mother.
All right. I reviewed the charging affidavit. I do find there is probable cause for the charge. Swear in the witness, please.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
I don't want you to tell me anything about this case or the facts of this case. My question to you is, are you afraid of your daughter?
Unfortunately, yes.
All right. Do you want her returning home to live with you because of that?
She lives in a separate residence,
Okay.
so that, yes. May I make a statement or no?
I would rather you not make a statement because anything you say can be used against your daughter in this proceeding. So let me ask you this. Are you afraid of any contact with her, or do you want simply non-hostile contact?
Non-hostile contact.
So you need to be able to communicate with her?
Yes, I do, as I'm the person who pays for her rent and living things and whatnot. She's not been able to work due to mental illness.
Okay. Is she currently being treated for any mental illness?
She doesn't believe she's mentally ill, so no. She has been Baker acted in the past.
Does the defense want to be heard on conditions of release?
Your Honor, given the alleged victim's testimony, would be asking for no hostile contact. They can maintain a separate residence because Ms. Brooks does live in a separate place. Additionally, she has no criminal history according to the face sheet that I have, so I would just be asking for the lowest permissible bond you'd be willing to give.
Okay. Does the state care to be heard?
Yes, Your Honor. The state would ask that we follow the bond schedule related to this case, and as far as we would also ask, given the victim's testimony, that a no contact order be put in place. No contact of any kind, not just a no hostile contact order.
Ma'am, would you have any hesitancy about calling the police in the event your daughter was to become hostile with you?
No, ma'am, I would not. She has no income, so I would request again your leniency in that.
All right. Then I'm going to set her bond at $1,000 with PTR conditions. I'm going to order that there be no hostile contact with the alleged victim in this case, that they are to maintain separate residences. Yes. It's bond plus PTR.
Your Honor, generally in Orange County, we don't do bond plus PTR. It's either PTR or bond.
Well, then it's going to be PTR because she doesn't qualify. I'm sorry, it's going to be bond because she doesn't qualify for straight PTR.
Your Honor, from hearing the testimony and everything, we were unable to talk to her, but at this time, she would meet the criteria for PTR. If you'd like to order that, would be
She
fine.
would?
Yes.
Okay. I was going based on the face sheet I was given.
Yes,
Then I will release her under PTR conditions and stay any
State would
bond.
object, Your Honor, to this? I'm sorry, object because
It's a crime of violence.
it's a crime of violence, and therefore they wouldn't qualify for PTR.
That's not true, Your Honor.
The judge has to make the Honor has to make specific findings as to why she would qualify, given that it's a violent offense under the statute, Your Honor.
Your Honor, then we just ask to make findings that she has zero criminal history, and that is why you're putting her on PTR.
All right. I will make those findings. I find that she has zero criminal history. I find that there has been testimony received by the court that she suffers from a mental illness, that she has recently been Baker acted. The affidavit indicates that her daughter has psychosis and at times hears voices, and I think it is appropriate for her to be released under, I'm going to make that PTR with mental health conditions.
Okay, thank you.
All right, given her situation. Thank you. Harry Mavronis. I can't hear him, but
Not you, Mavronis. V as in victory. Harry Mavronis. M-A-V-R-O-N-S.
all right. Thank you, sir.
got a motion.
I'm appointing the Office of the Public Defender to represent you. I am advising you that you are charged with trespass on property after warning.
Pass warrants.
I find that there is probable cause for the charge. He does not qualify for PTR.
Your Honor, he has a first appearance detainer for being out on bond.
May I be heard on that case?
You may.
Your Honor, in case number 2019 MM6940, he was arrested on August 19th, and no information has been filed to date, so we would ask that you take no action on that out-on-bond case.
What does the state say?
Your Honor, with regard to that case, if we could get 24 hours to follow up with it, we can hopefully provide that information.
Provide what information?
To see if there would be any charges within that, although if that seems unlikely.
Is it out of county?
Is this an out-of-county charge, Your Honor?
No.
I don't believe so.
It's an Orange County case.
But he's entitled to an ROR, right?
Then we would have no objection to an ROR.
I'm going to release some ROR. Thank you, folks.
Any action on the out on bond?
Ah. So he's out on bond for the battery charge?
Yes, that's the argument. I was making an argument that no information has been filed, and I was asking you to take no action. And then I'm assuming you ordered ROR on his current case, and
I
you were
did.
taking no action on the old case.
I am taking no action on the old
Okay.
case. That's correct.
Okay, thank you.
Johnny Taylor.
Yes, ma'am. Yes, Your Honor.
Yes, Your Honor.
Mr. Taylor, I'm appointing the Office of the Public Defender to represent you at this time.
For just the trespassing charge?
Would you like the Office of the Public Defender to represent you or not?
I would like to represent myself.
Then I will not appoint the Office of the Public Defender to
Okay,
represent
can
you.
we just settle this today?
Stand by. I'm going to appoint the Office of the Public Defender to represent you on an interim basis for today only.
Meaning what,
Pending
ma'am?
future qualification, meaning you've got a lawyer for today, but not going forward.
What I'm asking you today, Your Honor, is to, all it is just trespass.
Okay, no problem. Does the state have an offer?
Does the state have an offer they would like to make?
We do not have an offer at this time, Your Honor.
Active state probation, Your Honor.
I'm sorry?
Is active state probation. Violent felony
He doesn't want it, though.
social concern, detainer felony.
I can't force him.
That's correct.
Sir, let me remind you, you have the right to remain silent. Anything you say can and will be used against you in a future court proceeding. I've appointed an attorney to represent you for today, subject to future qualification, although I do have your paperwork and it shows you qualified, but because you've expressed a desire not to have that appointment, I'm only appointing her on an interim basis for today's proceeding, so you're not unrepresented. There is no offer from the state, so your bond is set at
That's incredible.
$500.
What?
You don't qualify for PTR, and there's no offer on the table.
Wow.
Angelica Fuentes.
Morning, Judge Richard Hornsby for Ms. Fuentes.
Good morning. Okay, Ms. Fuentes, you are charged with drugs trafficking in fentanyl in an amount greater than 4 grams, conspiracy to traffic in a controlled substance, and accessory after the fact to, well, a principal in the first degree. Probable cause was previously found. Counsel, would you like to be heard on?
Bond, yes, Judge,
Bond.
I'm asking the court to reduce the bond on count 1 at 10,000 and the remaining counts to either 100 or 1,000, whichever the court prefers. If I can just provide the background so you understand why I'm asking for it, I think it's justified.
Okay.
Judge, Ms. Fuentes was arrested on October 25th for trafficking fentanyl. It's actually described in the same affidavit that you may have reviewed for this case. For whatever reason, when they arrested her, they didn't charge her with these offenses that happened earlier in the day, and they didn't mention them in the arrest affidavit. I went before Judge Beamer on Thursday to do a bond hearing in that case, and for the first time, the officer who filled out this affidavit for arrest warrant came in and testified to all the same facts that are in the affidavit for arrest warrant. Obviously, I should have guessed it, but he waited till she bonded out that night, and then he arrested her the next morning when he filed this and re-arrested her on these charges. The information, Judge, that was presented at the bond hearing by her mother, and her mother's downstairs but isn't allowed to come up, was that both her parents are former military veterans. Her mother currently works for Veterans Affairs. They were both honorably discharged. She was living with her mother. Her mother rents. She just turned 20 years old, so she would qualify as a youthful offender. She has no prior criminal history. As a matter of fact, I think her only history of any sort prior to this was a speeding ticket. She went to Olympia High School. And as you can see from the affidavit for the arrest warrant, Judge, she was basically driving her friend Naya around, who's the co-defendant. They've known each other since high school. I guess it's one of the situations where she got caught up with her high school friends who were involved in the wrong things. So she's a lesser player of this. Her friend, the co-defendant, it's her boyfriend whose drugs she was apparently selling because he's currently incarcerated. Judge, her mother, candidly, they have me on a payment plan for the bond and the original case she was arrested on. The mother is on a $250 per month payment plan with the bondsman, so they're stretched to the limits. The mother testified she had no assets she could liquidate. The only thing she had was a retirement fund that if she were to liquidate it, it'd be worth about $5,000 after penalties. And so that's why I'm asking the judge, Your Honor, to lower it to $10,000. I don't believe she's a flight risk. And given her role in the case, she's obviously the lower player, and she's under 21 years of age, so I think there's a good case I may be able to get her a youthful offender sentence if she's ultimately convicted of these charges.
What says the state?
Your Honor, the state would respectfully request that we adhere to the bond schedule in this case and give the normal bond as opposed to what defense is asking for.
Even the what?
And give the normal bond that's been in the schedule as opposed to what defense is asking for, the 10,000.
Do you have any other facts you want me to consider in opposition to the request?
We don't have the warrant, Your Honor. Any of the facts included were already stated by defense.
And counsel, in the case that you've already had the bond hearing on, was the bond reduced to $10,000?
No, Judge. Judge Beamer reduced the bond in that case from $100,000 to $50,000. But this obviously, her mother was on a payment plan, so they don't have a lot of money. That's why I'm asking for 10. And I think that already secures her appearance in that case. And Judge Beamer was aware of these facts when she set that bond, Judge.
I'm going to grant the request to reduce the bond on count 1 from $50,000 to $10,000. I'm leaving the bonds as set on counts 2 and 3. And then I'm adding the criteria that she is not to possess or consume any alcohol or illegal drugs or controlled substances without a valid prescription. Anything else?
No, Judge. Thank you very much.
All right.
Thank you, Judge.
The case that, I'm not going to take any action on that case.
Thank you, everybody. Have a good weekend.
James Brady. Mr. Brady, I'm appointing the Office of the Public Defender to represent you. You're here based upon an alleged violation of your probation. Your bond was set at 0 in that case. Derek Griffin. Hold on, sir.
Was that hold on to Mr. Brady?
Yes.
Okay. Oh, I'm sorry. I should have pointed out that Kendall Ali entered a notice of appearance on August 19th for this case.
All right, well, then I'm only appointing you on an interim basis for today. Sir, apparently you're also out on bond in 2018 CT 5326 for other charges. I'm revoking your bond in that case as well, setting your bond at 0 at this time.
Could I have those, that case number? Also, this is a VOP, so there's no evidence that he picked up a new crime while on.
I had the wrong case number.
Oh, okay.
It is 2019 CF 7234. Burglary of a conveyance, possession of Xanax, possession of oxycodone.
Same argument, Judge. He hasn't picked up a new case, so he hasn't violated the conditions of his release in that case. And
What-
I would urge you to take no action.
What was the date of that case? He bonded on May 19th of 19.
Right.
In that case, these charges were picked up when?
This isn't a charge, this is a VOP. So he got a VOP.
Oh, they're not new
because-
charges? Okay, good enough.
Yeah.
I'll take no action. Thank you, counsel, for pointing that out. Derek Griffin?
Your Honor, on that one, that was what enacted the VOP, so the charges he's out on, it enacted this VOP, so if Your Honor.
Thank you. The one we just did, or Derek Griffin?
The one you just did.
Okay.
Yes, thank you.
Thank you. I'm appointing the Office of the Public Defender to represent you, sir. You're charged with battery, 1 prior battery, domestic in nature, assault, domestic violence, and possession of cocaine. I find probable cause for the charges. Bond is set at $1,000 for your possession of cocaine, $1,000 on the battery, $150 on the assault. You are to have no contact with the alleged victim. Thank you. And no contact means direct or indirect of any type. Do you understand that, sir?
Mr. Griffin doesn't know who the victim is. He would like to know who he's not supposed to have contact with. Is it Tulane Lewis?
Helene Lewis, correct. Frandy LaRose. I'm appointing the Office of the Public Defender to represent you. You're charged with 1 count of aggravated child abuse, I reviewed the charging affidavit. I do find there's probable cause for the charge. Bond is set at $1,000.
Your Honor, Eric Jakes with the state, we would also ask there be no contact of any kind
With no contact with the alleged victim, direct or indirect of any type. If you reside together, you're going to have to find another place to live for now. Do you keep those? Do you need those? Thomas Benjamin. Sir, I'm appointing the Office of the Public Defender to represent you. You're charged with one count of battery, domestic in nature. I've reviewed the charging affidavit. I do find there is probable cause for the charge. Ma'am, what is your name and your relationship?
Jacqueline Benjamin, wife.
All right, swear her in, please.
Raise your right hand, please. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, I don't want you to say anything about this case. My question for you is, are you afraid of your husband?
No.
Do you reside together?
Yes.
Do you have any hesitancy or fear about him returning to your residence?
No.
If he were to become violent in any fashion, would you have any hesitancy about calling 911?
No.
Then bond is set at, no, he qualifies for direct PTR, so I'm going to release you under direct PTR with the requirement that there be no hostile contact with the alleged victim in this case.
Your Honor, for the record, the state would still ask that there be a no contact order given the facts of this case. That would be no contact of any kind.
Pursuant to 907.041, the state objects to PTR as a dangerous crime.
Your Honor, I'd ask that you make findings that he has no criminal history, and that would be your reason for placing him on pretrial release.
But again, it's not the judge making findings, it's pretrial release making findings.
I'm going to find that he has no criminal history, and based upon the testimony I've heard from the alleged victim, I'm going to order direct PTR. Thank you.
Thank you.
Casey Clancy. Mr. Clancy. I'm appointing the Office of the Public Defender to represent you. You are charged with one count of battery, domestic violence. I've reviewed the charging affidavit. I do find that there is probable cause for the charges. Bond is set at $1,000. You're to have no contact with the alleged victim. You're also to not possess or consume any alcohol or illegal drugs or controlled substances without a valid prescription. Thank you.
Thank you.
Michael Muscat.
Case of mental health, Your Honor.
He'll be reset for tomorrow. Richard Alford. Mr. Alford,
I don't have that one, Your Honor.
you don't have the case, or it's not?
Yeah, it's not on my docket, so I don't know if he's already bonded or.
Is your name Richard Alford? Oh, I skipped somebody. Hold on. Let's go with Kenneth Thorne. You have that one?
Yes, that's
All
what
right.
I have next.
All right, I went out of order.
That's all right.
All right, Mr. Thorne, I'm appointing the Office of the Public Defender to represent you. You are charged with battery, unlawful touching or striking, I reviewed the charging affidavit. I do find there's probable cause for the charge. Ma'am, could you state your name and your relationship?
Sherry Horner, I'm his wife.
All right, swear her in, please.
Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Are you in fear of your husband?
Absolutely not. He swatted my hand.
He's what?
He
Swatted?
swatted my hand.
That, I don't want to hear any facts about the case. Anything you say can be used against him in a court of law. Do you have any fear, do you reside together?
Yes, we do.
Do you have any fear of him moving back in with you?
No, ma'am.
If he were to become violent with you in any fashion, would you have any hesitancy about calling 911?
Not at all.
Does he have any criminal history?
He used one misdemeanor conviction for resisting without violence in May of 2018.
Out of state conviction, Your Honor, possession of stolen property.
Oh, I didn't see those, I apologize.
PTR has indicated he qualifies for direct PTR, is that correct?
Yes, Your Honor.
Any hesitancy
Your
about
Honor?
that? You don't hesitate? He qualifies
Yes,
for,
yes,
okay.
yes.
May I hear from the state, please?
Judge, obviously, for the record, the state is going to object pursuant to Florida Statute 907-041. This is a crime of violence, domestic violence. If you read Florida Rule 3.131, referring back to 907-041, before you can release him on pretrial release services must certify that it has investigated everything that is listed, the circumstances of the accused family, employment, financial resources, character, mental condition, and length of residence in the community, the accused record of convictions, of appearance at court proceedings, of flight to avoid prosecution or failure to appear at court proceedings, and other facts necessary to assist the court in the determination. So the state is requesting that PTR make those findings on the record, and the court is not legally able to give this man pretrial release.
What says the defense?
Your Honor, I guess I would ask PTR to put on the record why they qualified him for pretrial release. They tend to be pretty picky about who they put on PTR, so I'm sure they'd be happy to put the findings on the record, because I can't do it apparently, so.
So the charges meet the criteria, Your Honor. The ones that don't would be murder, sex crimes, home invasion, crimes against children, carjacking, and any other capital life offenses. So the misdemeanor domestic charge meets that, and we do that on a weekly basis. Give misdemeanor PTRs and felony also that don't meet the murder, sex crimes, home invasion, crimes against, carjacking, any other capital. We did an investigation also of the community ties. We've talked with the victim. We've also verified through other sources that the person, and it can be either in the state of Florida or in another state, that they live where they live and they work where they work. The employment that we have for him is right now it's SSI, so he meets the criteria for our purposes.
Is the
And
state
his record
satisfied?
is good.
Is
They
the-
still object, Your Honor.
All right.
It looks right here.
I'm going to release him under direct PTR conditions, given the summation of information that PTR just provided, as well as the testimony of his wife.
Thank you.
I'm going to order that there be no hostile contact with the alleged victim. You will get a sheet as to what hostile contact, violent contact of any type would be a violation of the conditions of your release. And that will do it. Richard Alford.
Yes, ma'am.
Mr. Alford, I am appointing the Office of the Public Defender to represent you at this time. You're charged with possession of a firearm by a convicted felon and possession of ammunition by a convicted felon. Those are charges that entitle you to a bond, notwithstanding the no bond status in the warrant that was signed. I'm going to set a bond considering the affidavit in support, affidavit of arrest warrant. And your bond is set at $5,000 on each count. You are to possess no weapons or firearms and surrender any that you might have within 24 hours of your release. All right? Darius Bowie.
Yes, good morning, Your Honor.
Good morning. Mr. Bowie, I'm appointing the Office of the Public Defender to represent you.
Yes, ma'am.
You are charged with the following pursuant to an arrest warrant that was issued by Judge Clark. Possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, tampering with physical evidence, resisting an officer without violence, driving while license suspended, probable cause having previously been found. The bonds will be left as set in the warrant. That's it.
Oh,
Are there any other detainers?
Yeah, Mr. Darius Bowie?
Yes.
No other detainers
Okay.
at this time.
Charissa Colon or Cologne. Did I skip something? I'm sorry?
I don't have that person.
That person wasn't on our docket.
Well, she's on my paperwork.
They might have bonded already.
1803, 1810.
While you're check, she bonded? Yes. Okay. So Kobe Del Valle-Negron?
Del Valle Negron.
Valle-Negron, okay. Sir, I'm appointing the Office of the Public Defender to represent you. You are charged with the following: petty theft, possession of drug paraphernalia, possession of cocaine, possession of burglary tools, burglary of a conveyance, another count of petty theft, and another count of burglary of a conveyance. I reviewed the charging affidavits for these counts. I find there is probable cause for the charges. Your bond is set as follows: burglary of a conveyance, $3,500, petty theft, $100. The second burglary of a conveyance, $3,500, petty theft, $100, possession of drug paraphernalia, $100, possession of cocaine, $150, possession of burglary tools, $150. You are also out on bond in 2019 CF 10456. One of the conditions of that bond is that you not pick up any new offenses. Accordingly, I am going to revoke the bond in that case and order that you be held on a no bond status for now.
Your Honor, that was active PTR that he was out on. Would that be the same? He was active PTR, so we're revoking the PTR.
Was it active PTR? Yes.
Okay,
Thank you.
thank you, Your Honor.
I'll revoke the PTR.
Your Honor, could we also have a no contact with the victim in this case?
No contact with the victim? Who's the victim?
I see a victim listed as a Dennis Spencer Levy.
He was the owner of the car, correct?
Correct, Your Honor.
Did he own both cars?
He owned...
And is this a co-defendant case?
I don't have it as a co-defendant.
I don't have
case.
any co-defendants
I have it
here.
as two separate affidavits for, I think it's two different cars.
Do we even know the name of the owner of the second car?
Didn't say.
I'm not going to do a no contact order at this point. I don't think it's warranted.
Yes, sir.
O'Neill Goodman. Mr. Goodman, I'm appointing the Office of the Public Defender to represent you. You are charged with possession of MDMA ecstasy and possession of cannabis in an amount less than 20 grams. I reviewed the charging affidavit. I find there is probable cause for the charges. Bond is set at $1,000 on count one and 100, the cannabis charge is a misdemeanor, correct?
Yes, sir.
All right, $100 on count two.
The state would ask for an ROR on count 2, Your Honor. We don't want...
That's fine,
anybody-
ROR on
bonds.
count two. But not count one? Counsel, you're not asking for ROR on count one?
Not on count 1, just on the cannabis charge. Your
Okay,
Honor.
that
So
works
it's
for
not being
me.
held monetarily with cannabis.
Yep, so $1,000 on count one, ROR on count two. However, these new charges also get in the way of your release on two other cases. So I am revoking your ROR on 2019 CF 2396. But I'll give a bond in that case. It'll be $1,000 on count one and $100 on count two. I'm also revoking your bond in 2019 CF 014984. And I will give you a new bond in double the amount of the original bond.
Which is, I'm sorry.
Say again?
Which is how much, how?
I don't know. But he's out on a surety bond in that case, so
Yes.
whatever it was, it's doubled.
Okay.
Now, do you know what the charges are on the cases, the underlying that you just set bonds on? 'Cause we
Sure.
don't have the paperwork on that.
2019 CF 2396, possession of a controlled substance, count one.
Do we know what the controlled substance was?
Not on this, no. And possession of drug paraphernalia for count two. And the surety bond in the other case was possession of 3-4. It was the same charge, MDMA ecstasy.
All right, thank you.
Oh, I'm sorry, the bond amount is noted here, so it was $1,000?
So now it's 2,000?
So now it's 2,000, yes. I apologize, it was in a different spot.
That's all right.
All right. Rodney Grady. Let's reset him for tomorrow. Sean Greenlee.
Who was that you have?
Sean Greenlee.
I don't think I have that one. They might have bonded. If you give the number to someone, I think they can look it up and confirm that.
If we could see if Sean Greenlee bonded, case number 2000, you want the case number? He bonded? Great, thank you. Do you have Majed Hack? Okay. All right. I'm appointing the Office of the Public Defender to represent you. You are charged with the following: petty theft with 2 prior convictions. Probable cause was previously found. Your bond will remain set as it is in the warrant at $1,500 with the condition that you not return to the scene. Jatavius Hamilton. Jatavius, I had it right the first time. I'm appointing the Office of the Public Defender to represent you. You're charged with grand theft, 3rd degree of a motor vehicle. I find probable cause for the charge. I've been advised that you qualify for direct PTR and are a low-risk assessment. Not quite sure what that means, but I will accept it. You're released under direct PTR conditions.
Given that you qualify for PTR, we would just ask that they put those findings on the record pursuant to the statute 907.
I don't believe it's necessary in a nonviolent crime counsel.
My apologies, Your Honor.
Stephanie Lankford. I am appointing the Office of the Public Defender to represent you. Let me make sure I understand this. There's only one new charge, correct? PTR? Okay. You are charged with fraudulent use or possession of personal identification information. Probable cause was previously found and your bond was set at $1,000. However, PTR, would you clarify your face sheet for me, please? All of these other cases, is she currently out on bond in them? Or are they just open cases? Or are they old cases? Because there's about 15 of them.
So this is an add-on charge, correct?
Yes, this one that we're addressing today is an add-on charge. So the rest of them were ones that she originally came from.
Okay, then we're just going to leave it as is with the one new charge. Thank you, folks. Jose LeBron. Mr. LeBron, I am appointing the Office of the Public Defender to represent you. You're charged with possession of cocaine and destruction of evidence. I find probable cause for the charge. Bond is set at $1,000 on count 1 and $150 on count 2 for a total of $1,150. You are also out on bond in the case of 2019 CF 8991.
May I be heard on that case?
You may.
He was arrested on that case on June 23rd, and no information has been filed to date, so I would ask that you take no action. Did I say, I said June 23rd, right?
You did.
Okay.
Would the state like to be heard on that?
Your Honor, what is the charge in that case? We don't have it in front of us.
It is possession of heroin and possession of drug paraphernalia.
Your Honor, we would ask that the same bond be applied.
He's entitled to release because there's been 33 days and he hasn't been charged.
Then, Your Honor, we would have no
It only
objection.
applies, it only applies.
Judge, the 33-day rule that she's referring to that you take no action on only applies when somebody's in custody. So you can revoke his bond if it's been more than, once it hits 33 days, then he's entitled to release.
Then
If he hasn't had 33 days total in custody, you can revoke his bond now because he's committed a new offense. And if he spends 33 days total, adding together what he did before plus now, when he gets to 33 days, then he would be entitled to release. The fact that it happened, hasn't been charged in several months is irrelevant. We have 175 days to file charges under speedy trial, and we can use every day of those 175 days if we want to.
May I briefly respond if it's necessary?
You may.
Your Honor, I am making the argument just because I think that no action should be taken, given what 3.134 says. It makes no mention that someone remain in custody for 33 days. If you look at the plain reading of the statute, I'm not aware of any case law that interprets 3.134 in such way. Pursuant to the rule of lenity, we should read 3.134 in a light most favorable to Mr. LeBron. And again, I'd ask that you take no action because they still haven't filed charges, and he shouldn't be held no bond on something the state hasn't filed on.
absolutely can be held no bond on something the state hasn't filed on, because what the law says is that if you are only entitled to a bond and then once probable cause has been found for a new offense, and the rule actually does say that you have to be in custody for 33 days. In fact, the legislature is talking about revising the rule so that it would be, if a defendant is out of custody for 60 days, then he comes off of his release. If you want us to look for case law, we can certainly find it for you, but the rule actually says it's the 30-day rule and then you get 3 extra days. It's in custody defendants.
Here's what I'm going to do. I'm going to revoke the bond, but I'm going to double the previous bond. So I'm going to give him a bond. It looks like the original bond was $1,100. It's a little unclear on the writing. So by doubling it, it would up it to $2,200. My guess is it was $1,000 for count 1 and $100 for count 2. So each of those bonds is doubled.
So it's 2,200, or are you doing 1,000 and, or 2,000 and then 200, right? For those
Doubling the
counts?
bonds would then be $2,000 for count 1, possession of heroin, $200 for possession of drug paraphernalia, and then leaving the bonds as I previously set for the new charges.
Thank you.
Damahri Marks.
Yes. Yes.
I'm appointing the Office of the Public Defender to represent you. You are charged with tampering with a witness. Probable cause was previously found. Would the state care to be heard on bond?
Your Honor, we don't have the charging affidavit for this one, so if somebody could provide it to us, I would appreciate it. Can you tell us what you said the charge is tampering with a witness. Can you tell us in what type of offense he's charged with tampering with a witness?
Grand theft, third degree of a motor vehicle.
Tampering with a witness in a grand theft motor vehicle case?
Yes. Let me double check. That is my recollection.
Is the tampering listed as a third degree felony?
Yes.
Okay, I'm asking because that's why it matters, because if it was, like sexual battery, it would be a first degree felony or a life felony. So the state would have no problem with a $5,000 bond, Your Honor.
The warrant was a zero bond.
Probably until initial appearance.
Right, and there's a note that says it may be modified at IAs. So I will set bond at $5,000 on that charge. He is currently out on pretrial release and ROR in 2019 CF 9251, and he's currently out on bond in 2019 MM 985. I believe the grand theft third degree charge that he's out on bond is the same victim as in this case that was threatened. So, I'm going to revoke your bond in the grand theft third degree motor vehicle case and the burglary of a conveyance case. I'm going to revoke your ROR. There is no bond. I'm going to revoke your PTR in the grand theft, third-degree motor vehicle case, and your ROR in the burglary of a conveyance case. I am going to set a bond for you. I'm going to set your bond at $5,000 in the grand theft case, 2019 CF 9251, and $1,000 in the burglary of a conveyance charge, which is the same case. I'm going to take no action with regard to 2019 MM 985, the loitering or prowling case. You're to have no contact with the alleged victim in this case. Any contact by and of itself will constitute a violation of the conditions of your release. $5,000 and $1,000 on the yellow page. 5 and 1. Yeah. For that one, 5,000 and 1,000. Carlos Molina.
Yes, ma'am.
Did you get the other part of that? Okay. I'm appointing the Office of the Public Defender to represent you. You're charged with aggravated assault, battery on a law enforcement officer, resisting an officer with violence, depriving an officer of means of protection or communication. I find probable cause for the charges. Bond is set at $1,500 on count 1, $2,500 on count 2, $1,000 on count 3, $150 on count 4. I'm taking no action on the open petty theft case found at 2019 MM 7771.
Your Honor, with regards to the civilian victim in the assault case, could we have a no contact order with Mr. Jared Shannon, please?
Yes.
Thank you, Your Honor.
Thank you. Luis Montanez Martinez.
Yes. Yes.
I'm appointing the Office of the Public Defender to represent you. You're charged with aggravated battery with a firearm, which actually discharged. I reviewed the charging affidavit. Disregard. I've reviewed the warrant. Probable cause was previously found. The warrant set your bond at 0, but I believe you're entitled to a bond at IA's. Is that correct, State?
Yes, Your Honor.
Thank
Yes, Your
you.
Honor, he's entitled to a bond in accordance with the charge of...
However, he's facing a 20-year minimum.
However, he is facing a 20-year minimum mandatory, and with the charge being aggravated assault with a firearm. Or aggravated battery with a firearm, my apologies.
Bond is set at $10,000. You're to have no contact with the victim. And you're to possess no weapons or firearms as a condition of your release. Jamar Morris.
Yes, Your Honor.
I'm appointing the Office of the Public Defender to represent you. You are charged with burglary of a conveyance with an assault and/or battery. Probable cause was this an arrest warrant, warrant arrest?
Yes, Your Honor.
All
This
right.
was a warrant.
Probable cause was previously found, and your bond was set at $20,000, where it will remain. You're to have no contact directly with the victim or any co-defendants or witnesses, and you're not to return to the scene of the offense. Joseph Morris.
Oh, okay, thank you.
I'm appointing the Office of the Public Defender to represent you. You are charged with possession of MDMA, ecstasy, possession of cocaine, resisting an officer without violence. I find probable cause for all of the charges. Your bond is set at $1,000, $150, and $100 respectively. You are well, that's it. Mark Shrieken. I'm appointing the Office of the Public Defender to represent you. You are charged with possession of cocaine and possession of drug paraphernalia. After reviewing the charging affidavit, I do find there is probable cause for the charge. Your bond is set at $1,000 on count 1, $100 on count 2. Jerome Taylor.
That's not for you. I'm just looking through.
I'm appointing the Office of the Public Defender to represent you. You are charged with 3 counts of petty theft, each with 2 prior convictions. These are all third-degree felonies. These were all warrant arrests. Probable cause was previously found. Your bond on each of these, well, disregard. Your bond on the first 2 counts is $1,500 each. Your bond on the third count was set at $1,000. Let me make sure I read that right. Hold on.
I had 3 different warrants with 1 count of petty theft, 2 priors on each one.
Right, but the bond amounts are different. So on 19-98617, your bond is set at $1,500. On 19-14547, your bond is set at $1,500. And in the third case, your bond is set at $1,000. Oscar Terraza. I'm appointing the Office of the Public Defender to represent you. You're charged with burglary of a conveyance, attempted aggravated battery, and criminal mischief in an amount less than $200. Probable cause was previously found by the judge issuing the warrant. Your bonds were set at $3,500, $1,500, $100, and $100 respectively. There they will remain. Does the defense care to be heard on whether or not these new charges should violate his conditions of release or his bond conditions under 2019 CF 11780? Which include charges for battery, DV, and improper exhibition of a dangerous weapon or firearm.
Your Honor, I don't have a good faith basis. The state filed an information on August 18th, and he's represented by Jack King in that case.
Okay, thank you. Then one of the conditions of your release is that you not pick up any new charges. You picked up new charges. I'm revoking your bond in 2019 CF 11780, setting your bond at 0, no bond at this time.
Your Honor, we would also ask for no contact at all order with the victim.
In the new case,
Yes, Your Honor.
there's to be no contact with the victim.
Thank you, Your Honor.
Leroy Ware.
Yes, ma'am.
I'm appointing the Office of the Public Defender to represent you. You are charged with the following: 1 count of possession of cocaine, 1 count of possession of drug paraphernalia, and 1 count of possession of a Schedule 5 controlled substance. After reviewing the charging affidavit, I find there is probable cause for the charge. All the charges, your bonds are set at $1,000 on possession of cocaine, $100 on possession and/or use of drug equipment, and $150 on possession of a controlled substance. That's it. Willie Whitlock. Mr. Whitlock, I'm appointing the Office of the Public Defender to represent you. You're charged with aggravated assault with a firearm, shooting or throwing a missile into a dwelling, structure, or vehicle. After reviewing the charging affidavit, I do find there is probable cause for the charges. Bond is set at $10,000 on each count. You're to have no contact with the alleged victim. You're also not to go within 1,000 feet of that residence. Edwin Otero. Thank you. Ralphie Quiles Colazo.
Yes, ma'am.
I'm appointing the Office of the Public Defender to represent you. You are charged with DUI with property damage. I've reviewed the charging affidavit. I do find there is probable cause for the charge. Bond is set at $1,000. You are with the condition that you not possess or consume any alcohol or illegal drugs or controlled substances without a valid prescription. Edward Bennett.
Yes, Your Honor.
Mr. Bennett, how are you today?
All right.
I'm appointing the Office of the Public Defender to represent you.
Thank you.
You're charged with 1 count of simple trespass, and I've reviewed the charging affidavit. I do find there's probable cause for the charge. Is there an offer from the state?
Not at this time, Your Honor.
Why not?
If you give me a moment, I can trespass. If you give me a moment, I can look over the facts, make sure that it's warranted, make sure there's not a civilian victim here.
I'm not requiring that you make an order. I'm simply asking why not. If you're not prepared to make an order, I will accept that, but I need to understand why not.
We weren't provided with the criminal histories, Judge, and that's a big part of the reason why we're not making offers here, because we don't have the access to the computer and we don't have the criminal histories.
Okay. And you're not comfortable making an offer without the criminal history?
Correct. If Your Honor has criminal history and you want to share that with us, we could certainly consider something.
I have the criminal history summary that was provided by pretrial release, which indicates no DOC, 0 felonies, 34 misdemeanors, 12 failures to appear, the last one in November of 2014, 56 UNK unknowns. Florida convictions: marijuana possession with intent to sell, manufacture, or deliver, Schedule 1, DUI, multi, DWLS, multi, larceny, petty theft, multi, trespass after warning, multi, soliciting, trespassing on property or conveyance, twice, violating a county ordinance, violation of a use of state right-of-way, multi, failure to leave property upon order by owner, multi, trespass on property other than a structure or conveyance.
Your Honor.
And it goes on.
7 days in the Orange County Jail.
What was the offer? I'm sorry.
7.
7? Let me convey that.
Just so you know, there's more. Is he accepting the offer, counsel?
Oh, yes, Your Honor.
Mr. Bennett,
Yes?
I have described the nature of the charge to you. You have the right to you have the right to contest the plea and proceed to trial if you will. Do you understand that right?
Yes.
Have you had a full opportunity to discuss the offer with your attorney?
Yes.
Are you currently under the influence of any drugs, alcohol, or illegal substances that would affect your judgment today?
No.
Do you want to accept the offer?
Yes.
Anybody forcing you or threatening you to accept the offer?
No.
Then I will accept the offer. I adjudicate you guilty of the charge of simple trespass. I order that you are to be incarcerated for a period of 7 days with credit for time served of whatever you've got thus far on this charge, which is how much? Anybody?
2 days.
2 days with credit for time served of 2 days. You're ordered to pay all standard court costs and fees, which I will reduce to a judgment if you would like. Would you like that?
Yes, Your Honor.
All right. I will reduce all fees and costs to a judgment at this time. Did I miss anything?
I don't think so.
All right. Thank you, folks. Laveris Foster. Is that you?
Yes, ma'am.
All right, Mr. Foster, I'm appointing the Office of the Public Defender to represent you. You're charged with trespass on property after warning. I reviewed the charging affidavit. I do find there is probable cause for the charge. Would pretrial release like to put his prior history on the record?
This is Laverius Foster, Your Honor.
I'm sorry?
Laverius Foster.
We are on Laverius Foster.
His history is 4 felonies, 18 misdemeanors, 0 failure to appear, 0 unknown, 0 GC. His convictions are possession of controlled substance, resisting officer without violence ×3, battery on Leo, possession of cocaine ×2, possession of cannabis, possession of drug paraphernalia ×4, multiple municipal ordinances, multiple petty thefts, trespass, multiple trespass on other structure, different types of trespass, Your Honor. And out-of-state history, convictions, 0.
Thank you.
Your Honor, the offer would be 10 days, Orange County Jail.
State has made an offer for 10 days. Would you like an opportunity to discuss that with your client?
Yes, just a moment, please. He will accept the offer, Your Honor.
All right. How much time does he have credit for time served? All right. Sir, you understand that an offer has been made by the state for an adjudication of guilt in exchange for 10 days in the Orange County Jail with credit for time served of 2 days?
Yes, would you like a look?
Have you had an opportunity to fully discuss the offer and the consequences with your attorney? Sir, I'm asking you.
Yes, ma'am. Yes,
All right.
ma'am.
All these questions are going to be for you now, not me.
Are you currently under the influence of any drugs, alcohol,
No,
or
ma'am.
illegal substances that would affect your ability to make this decision today?
No, ma'am.
Anybody forcing you or threatening you to enter into this agreement?
No, ma'am.
Are you entering into it freely and voluntarily?
No, ma'am. Yes, ma'am.
Are you satisfied with your attorney's representation of you?
Yes, ma'am.
Then I will accept the plea. I find that it's reasonable under the circumstances. I adjudicate you guilty of the charge of trespass on property after warning. I sentence you to 10 days in the Orange County Jail with credit for time served of 2 days in the Orange County Jail. Do you want all the costs and fees reduced to a judgment?
Yes, Your Honor.
I will do that. Anything else?
Nope. You
All
have
right.
it.
Thank you. Hazel Raboon, or Raven. Thank you. Richard Wilson.
Yes, Your Honor.
Mr. Wilson, I'm appointing the office of the public defender to represent you at this time. You are charged with defrauding an innkeeper in an amount less than $300, resisting a merchant, and resisting an officer without violence. I've reviewed the charging affidavit. I do find that there is probable cause for the charge. Bond is set at $500 on count 1, $100 on count 2, $100 on count 3. You are also not ordered not to return to the Splitsville restaurant located in Disney Springs. James Wonder.
His behavior, Your Honor.
We'll recall him for tomorrow. Tacita Coverdell. I'm appointing the Office of the Public Defender to represent you. No, I'm not.
I was saying, we don't need to on the out-of-county.
Sorry. In Osceola, we do all the out-of-counties together, so I didn't realize it was split
Yeah, we're
up
done.
at the end here.
Yeah.
All right, disregard that. You are here based upon an out-of-county warrant issued out of Seminole County. Your charges are possession of heroin, and your bond was set at $3,000. Donna Hodge? No.
This is Stephanie Powell.
Did we miss Donna Hodge? What happened to her? Sorry?
What's the booking number? They could probably tell you if she bonded or something.
She was held on out-of-county warrants out of Charlotte County. And they were all, well, here, stand by.
1903, 1795.
Okay. Stephanie Powell. I am appointing the Office of the Public Defender to represent you. You are here based, is this a warrant too?
These are all out of county.
These are all
This is
out of
next
counties.
couple.
Disregard that. You are here pursuant to an out-of-county warrant issued out of Lee County, Florida for scheme to defraud was the original felony. You're to be held on a no bond status at this time. Nicholas Schoenwit.
Yes, Your Honor.
Mr. Schoenwit, you are here because of a warrant issued out of Volusia County for carrying a concealed weapon. You're to be held on a no bond status at this time. Priscilla Scott. Ms. Scott, you are here based upon out-of-county warrants, 3 of them specifically. 1 out of Pinellas County, looks like they're all out of Pinellas County. All right. The Pinellas County warrant under agency case number 2019 WA 4284, actually the court case 19-12623, set your bond at $5,000. Pinellas County case 19-8206, set your bond amounts for the warrants respectively at $50,013 for count 1 and $1,000 for count 2. And that makes 3. Jesse Terrell.
This is our last out of county.
Mr. Terrell, you're here based upon a warrant issued out of Seminole County for violation of your probation. Underlying charge was possession of cocaine and driving under the influence. Your bond was set at 0 by Judge Alba. Nicole Hansen. I'm appointing the Office of the Public Defender to represent you.
Thank you.
You are charged with assignation to commit prostitution. Your bond is set at $500.
Your Honor, would you consider releasing her on her own recognizance since she doesn't have any criminal history?
Well,
That's what my face sheet says.
Yes.
I also need to find probable cause, so I did find probable cause, because I don't believe that was found previously by Judge Carter. So I do find probable cause for the charge. Let me see what PTR says. Any objection by the state to ROR?
No, Your Honor.
I would consider that, and I will do that. So she's released ROR. Thank you. Arcadio Cruz. Mr. Cruz, you're here on two cases. First, let me start by appointing the Office of the Public Defender to represent you in each of these cases. You're charged with driving while license suspended with 2 prior convictions. I find there's probable cause for the charge. Your bond is set at $2,500. You're also charged with violation of your probation. PTR, can you tell me what that case is and what that, was there a warrant issued for violation of his probation, or is this
On view, Your Honor.
on view? What was he on probation for? And what's the case number?
He's active probation for simple battery. The case number is 1814203. And it ends 6/24/20.
Say that again?
It ends 6/24/20.
20. I thought you said 10. I'm finding an on-view violation of the conditions of your probation, setting your bond at 0 on that count. Carlos Torres Giles. I'm appointing the Office of the Public Defender to represent you. You are charged with violation of your probation. Underlying case involves a battery. Your bond is set at 0. Sebastian Fernandez.
Afternoon, ma'am.
And I'm appointing the Office of the Public Defender to represent you. You're charged with 1 count of disorderly conduct. I have reviewed the charging affidavit. I do find there is probable cause for the charge. Would PTR place the defendant's criminal history on the record, please?
This is Sebastian Fernandez, Your Honor.
It is.
Thank you. 1 felony, 4 misdemeanors, 2 failure to appear. His last conviction was 10/14/19 for drug equipment. His Florida convictions are flee and elude Leo, 2 municipal ordinances, disorderly conduct, and drug equipment possession. No out-of-state, well, I'm sorry, Your Honor, he has history, but no out-of-state convictions.
Thank you.
I'm sorry, Your Honor. One moment, Your Honor, I'll take a look here. It's disorderly. Your Honor, they offer 7 days in this case.
One moment, Your Honor. Your Honor, if Mr. Fernandez did not take the offer, would you be inclined to release him as on recognizant? It's for his consideration of the plea.
I don't think the two
I
can
have,
be
I have,
connected.
I have a mental health appointment at the VA hospital next week.
I didn't hear what you said.
I have a mental health appointment at the VA hospital. I also got to see compensation and pension about my disability claim. I did 14 years Army, just trying to fix myself.
If he's a veteran, it would probably be in his best interest to not take the plea, actually, because he may or may not qualify for Veterans Court with that criminal history. I'm not super familiar with what does or does not qualify somebody for VA, for
Veterans Court, yeah.
That court, yeah, Veterans Court, thank you.
So are you withdrawing the offer?
I mean, if he wants to take it, but I'm just kind of putting it out there, I honestly don't know if he qualifies for it or not. I'm not, that's not something I do, but I don't want him to take a plea offer if there's a chance he could.
Let's do this. Any objection to release ROR? He doesn't qualify for PTR.
If he doesn't qualify for PTR, he's not going to qualify for the RO, through the state's program, because of his criminal history, he's not going to qualify for the ROR program through our office.
Bond is set at $250.
He wants to know if it's too late to take the offer. He just can't afford any bond, so he was going
Any bond?
Yes, that's why. He can't, so that's why he wanted to know if you'd ROR him, because if you're not going to ROR him, he wants to take the plea. That's why I asked that question.
Does he have, when did he get arrested, yesterday or today?
I was arrested yesterday.
5 days. 5 days in the Orange County Jail for his plea offer.
I can work
He'll already
that.
have
Sir.
credit time served, he only needs to do 3 more.
Sir, are you feeling pressured to take this plea so that you can make your veterans appointment?
Yes, I've actually been working with that. I have regulars on the road when I panhandle. They ask me how I'm doing, and they actually help me out with bus money.
How long have you had this appointment set?
It's about every month. I filed March 4th, my disability claim. I've been diagnosed in VA psych ward with PTSD, generalized anxiety, and major depression. Did 14 years active. I was part of the downsize. My DD-214 is honorable with reduction in force comments. I did 3 years in the reserves.
And why does he not qualify for PTR?
His history wasn't the pre-criminal. He does not have community ties. We could not verify them to give us any information on that, so.
So you show he's a transient?
We haven't listed that yet. Your Honor.
Do you have an address in
My
the area?
parents live at 829 Eastman Court over in Waterford Lakes. I currently do not know where my wife and kids are on the east side because my parents won't reveal that to me, but they actually are in contact with my wife and my kids. I've lived here in Orlando for 4 years. I used to stay out a little bit past Alafaya in Alafaya Palms, a trailer park, and then I moved out to Deerwood, which was a mobile home community. I had child services 2 years ago. That case has been resolved, but my wife has benchmarks for me to come home.
How does that impact your decision at all, if at all? It does not? Okay. All right.
Judge, I just discussed with defense counsel, I don't know what day is his appointment. I don't want to pressure him into taking the plea, but at the same time, I don't want him to miss his appointment. What day is the appointment?
My mental health is on Tuesday, and then pension compensation is on Thursday, man.
Okay, so if he takes, again, I don't want to pressure him into taking it, and if he would qualify for Veterans Court, but if he took 4 days, I think he could make it. We'll do 3 days to make it safe.
I will take 3 days right now, man. I'm used to having 2 days, so I can do that.
If 3 days gets him to the appointment, the state doesn't have any problem with him doing 3 days, but of course wants to make sure he could qualify for Veterans Court, so obviously I'll let his attorney discuss that with him, but the state's fine with 3 days.
Counsel, you understand the concern with your client accepting a plea at this stage of the proceeding, which is in his desire to quickly get out so he can make his appointments.
Yes.
He may very well skew his eligibility for the exact relief he's trying to get. And nobody can represent whether that will or will not happen in this venue.
He's indicated to me that he's not, and he's already done Veterans Court before in another case. So I don't believe he would qualify again. I don't know for sure. I've only referred a few clients.
I don't think it's Veterans Court that we're talking about. I think it's the Veterans Benefit Program.
Oh, he's a kind of.
No, I was talking about Veterans Court.
Oh, you were? Okay.
Yeah, I was talking about Veterans Court.
Mhm. Yes, the fleeing and eluding case from 2017.
Kind of killed your chance, didn't it?
Yeah.
All right.
Yes.
All right, so the offer at this point is 3 days?
To ensure that he makes that appointment.
With how much time, credit time served? 1 day?
2. It's going to have 2 if he was arrested yesterday.
With 2 days credit time served? With an adjudication of guilty of the crime of disorderly conduct?
Yes, I will plead no contest, ma'am.
Okay. Then I'm going to accept your plea. You've had enough time to talk with your lawyer to be satisfied about the potential ramifications of a guilty plea, or a no contest plea?
I understand, ma'am.
You understand you'll be adjudicated guilty of the charge?
Yes, I understand, ma'am.
Are you currently under the influence of any drugs or alcohol that would affect your ability to make this decision right now?
No, I am not, ma'am.
Anybody forcing you to make this decision?
Nobody is.
Okay. Then I'm going to accept your plea. I find that it is freely and voluntarily given, and you're satisfied with your attorney's representation. I find that the defendant is competent, coherent, and alert, and is knowingly entering into this agreement. So it's 3 days credit time served for 2.
Thank you, court, for your mercy.
Anybody left standing in the hall out there that we forgot?
I think so.
Any other matters we need to address?
Not that I'm aware of.
Yes, Your Honor.
Yes.
2 things. You have something? Go ahead.
No, I said not that I'm aware of, so I.
Yes, Your Honor. For Tavius Hamilton, he was ordered PTR for the grand theft 3rd degree, is that correct, for motor vehicle?
I don't know.
It doesn't, it just says bond saved, I have a PTR, so we wrote down PTR, all 3 of us. So.
Can I see the paperwork? I'll see if I can remember that.
Also, Your Honor, in Osceola, that they do with mental health conditions, but here in Orange County, could we have bond or mental health PTR if qualified? Because that is, they'll still be able to bond out if they want to, but the mental health PTR sometimes takes several days for them to get in front of them, but we don't have a mental health conditions. We wouldn't know what to do with that. We'd have to bring it back in front of you tomorrow. So I wanted to, if she needed to bond her daughter out, the first lady, it was Mrs. Brooks, Bethany Brooks.
So you don't have in Orange County, I thought mental health PTR was the tougher standard, and if that didn't work, then it would just be PTR with mental health conditions.
Well, if you wanted to do PTR, I can make sure that I put her with the mental health. I'll do that. It doesn't have to, if it says mental health on there, that has to go through our mental health thing. So if you just put PTR, I'll make sure that she goes through our mental health person over there.
I think that's consistent with what you were asking for, because I remember with that case, you ordered her to PTR
It's
with
the
mental health
verbiage.
conditions, but they don't have mental health conditions, but it seems as though they have officers who specialize in dealing with mental health.
I understand.
So would you like for me to do PTR and make sure she goes through mental health?
Yes.
I can do it.
Thank
So
you.
with that.
So that one's taken care of. So the only other one we have a question on is this Terraza Oscar?
The other question was for, his name was Jatavius Hamilton.
Close for no cigar.